Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. Um, I thought I would just give an overall summary of the more popular items which make someone inadmissible because it is such a big area in immigration law. I'm sure either you or someone you know has tried to come into the United States and they couldn't, and they were rejected. And the question is, why were they rejected? Why is it so difficult in which to get into the United States? And so there is a whole plethora of items that make someone inadmissible. Now, what does inadmissibility mean? Well, that basically means that you, for one reason or another, cannot come into the U.S. Now, there's lots of waivers and ways to work around that, but the first things first is, one needs to determine if you're inadmissible, and if you are inadmissible, why you are inadmissible. So what I want to do is clarify some issues because sometimes people actually think they're inadmissible, but they're not, okay? Although it's more likely the other way around. So without going into all of the different grounds, let me go into the more popular ones. So first would be, I would refer to as 212A9B, okay? This is unlawful presence. Now, this is different than being out of status. So for example, let's say you come in on an F1, you go to school, and then, your parents stop sending you money, you drop out of school, and you start working. Okay, well, that means you are out of status. You are violating your status, but you're not unlawfully present because essentially there's no termination date of the F1. It's just duration of status, however long it takes. So first things first, of course, if you're going to be inadmissible under unlawful presence, you need to be unlawfully present, not just out of status. Okay, so the next one is 212A9C. Okay, this is when, and it varies, but this is when you have, there's two different ways you can be subject to this. One, that you have received a removal order or an expedited removal order. So again, either you were at the border and you were expeditedly removed, not just voluntarily returned, or you were in immigration court and you were issued a removal order and deported. If you come back into the United States, EWI, which means you enter without inspection, then you become subject to the inadmissibility ground under 212A9C, which means that you must remain outside the United States for 10 years in order to even apply for a waiver to be able to again come back. And there'll be a whole nother video on what kind of waiver that is and the burden and so forth. Another way that you become subject to 212A9C is if you, and this is when you don't have a removal order, this is when you enter the United States, you've been unlawfully present for more than a year, okay, and then you leave, and then you come back again without inspection. You're EWI again, and that triggers the 212A9C ground of inadmissibility. Now, there's an issue here that a lot of people incorrectly think that if they enter without inspection once, and they leave, and then they enter without inspection again, that they're automatically subject to 212A9C, and that's not the case. Okay, in order to be subject to it, it doesn't matter that you have entered without inspection more than one time. You could do it 10 times. The issue is whether cumulatively you have been unlawfully present in the United States for more than a year. Then you become subject to it. So, when people come into my office and I'm determining how they might be inadmissible, naturally, I will first determine how long they might have been unlawfully present in the U.S., how they entered, because, for example, let's say that, and it gets into, issues like this, but let's say that they were unlawfully present in the U.S. for more than a year, then they got someone else's green card, entered the United States, with someone else's green card. Well, the question is, are they then subject to this permanent bar where they have to be outside for 10 years and apply for a waiver? And the answer is no, because they didn't enter iwi. They didn't enter without inspection. They entered, it was someone else's green card, and now they're subject to another ground of inadmissibility for fraud and misrepresentation, but they're not subject to the permanent bar. Okay, hopefully you've got that distinction. Next are a whole plethora of crimes, which I have done, and I can do more in the future videos on which crimes specifically make someone inadmissible, but that falls under 212H. And there's an exception to 212H where you don't need a waiver and you're not inadmissible, and that's the petty offense exception. So the petty offense exception is a good item to keep in mind if you're trying to get in, because sometimes you say you stole some gum and the officer says, oh, inadmissible under 212H, and it's not true. Depending on what your sentence was, what the maximum possible sentence for this type of crime is, and how much you served and so forth, the petty offense exception can be argued as to why you're not inadmissible under 212H. Okay, now false claims to citizenship, that's a biggie. And unfortunately, immigration looks at that worse than a lot of crimes, and a lot of worse crimes are waivable, whereas this one's not. But with this one, you have to look at when they applied for when they claimed to be a U.S. citizen. If it was before September 30th, 1997, then it's before the law came into effect. It's not retroactive, and basically you just committed fraud, of which there is a waiver, rather than claiming to be a U.S. citizen. There's also ways to get around that, which just briefly, if you didn't actually make the claim to U.S. citizenship, or you actually thought for a verified reason that you were a U.S. citizen, there's different ways. But bottom line, don't claim you're a U.S. citizen, because it's very difficult to get around. Another one is what's called 212A1. Now, this doesn't fall under a crime, and it deals with drugs. But this is not where you have a conviction for possession or possession for sale. It's just based on the evidence and based on the medical interview, basically, where you were speaking to the doctor. It's determined that you're a drug abuser, and there's no waiver for this. However, after you've had this determination, if you wait 1 year, you can apply again and show remission and rehabilitation, and that you haven't and will not use again. So that's how essentially you get around that one. Next is a 212A3. That's a gang member. The U.S. doesn't want gang members basically coming in the U.S. because of crimes and so forth that could be committed. So that would be the next ground. Again, we're going to have a whole nother video on tattoos. Okay, that is a whole issue of how immigration, ultimately finds that you're inadmissible and doesn't let you in, but there's ways of arguing around that as well. So wait for the tattoo video. And then a lot of times people get what's called the 221G ground of inadmissibility, and that basically means they just didn't provide enough documents. Now, there's a usually always a way around that, and number one is to provide them what they need. Okay, so if you were unable to do that, then basically I have those people come to my office, I have them show me the denial, and then we just get the necessary documents and argument to try to get them through. Okay, so that's, again, there's a lot that I left off. I'm just putting the more popular grounds of inadmissibility. But if you like the video, click like, subscribe, and also you can call my office for consultation. I'll let you know how I can help you. Okay, more on the coming videos.